how I first got into futility. I chaired the bioethics committee for the LA County Bar Association, and at the time the membership decided that one of the issues on which we needed greater legal clarity for the medical profession was on medical futility, and still working on it a decade later. All right, so let's get to work. All right, so what I'm going to do is provide a very quick orientation because I think that most of you probably don't even need that much. So this is a physician here kneeling over a tombstone with a stethoscope, and the wife is standing over him, and he says, "I'm afraid there's very little I can do." This cartoon is very apt because medical futility is often framed as a problem of surrogate-driven overtreatment. The clinician thinks that the appropriate course of action is comfort measures only, but the surrogate wants to continue life-sustaining medical treatment, right? And there's two other distinctive features here. One is these disputes usually concern patients in the ICU, and the other is that these patients that we're talking about almost always lack decision-making capacity, right? So that's enough of the orientation. Here is my roadmap for the next 45 minutes. First, I want to quickly address the vocabulary and then the prevalence of medical futility disputes. I want to look at the causes of the disputes and how to prevent them from arising in the first place, and then how consensus can be reached. And then, in fact, since you invited an attorney to speak with you, I'm going to spend most of the time on the last final step 6 on what to do in the intractable conflicts. All right, so vocabulary. Does anybody know what this is? So this is the symbol that represents the artist formerly known as Prince. And I thought of this, and I thought, you know, what we probably need is a symbol to represent the concept formerly known as medical futility, because it's such a disputed and contested concept and term. And let me just give you an example. So for the last couple years, I've been working on a multi-society statement on medical futility because the current ones from the AMA and others all date from the early 90s, so we're trying to update that. So this is being drafted by the American Thoracic Society, Society of Critical Care Medicine, American College of Chest Physicians, American Association of Critical Care Nursing, and the European Society of Intensive Medicine. Not yet published, still in draft form, but let me just tell you the vocabulary that we're using here. What we did was we broke up the concept of futility into 3 categories, which are called futile treatment, inappropriate treatment, and provisionally inappropriate treatment. Futile is reserved for its truly the core sense of what futile means. So it's reserved for physiological futility, for things that won't even work, right? Not even effective at all. And then the examples that are given are things like CPR for a patient with rigor mortis, right? Clearly clearly futile. Inappropriate is for treatments that are basically illegal, right? They might work, but they're proscribed. So for example, maybe the request from the surrogate is to somehow circumvent the organ allocation rules, right? Get you higher listing in the UNOS list, right? It might work, but it's illegal. So that's inappropriate treatment. Everything else is provisionally inappropriate. And the upshot of this is the policy, the draft model policy, basically says in the algorithm that clinicians can just refuse futile treatment and they can just refuse inappropriate treatment. In fact, they should, right? They should. It's not just an option. But as far as provisionally inappropriate treatment, they have to go through a 7-step process that looks not terribly different from the AMA model policy or from the UCLA futility policy. And so I just would note that in the recent UCLA-based WEN study, right, the clinicians identified several different definitions of futility, right, that the treatment requested won't meet the patient's goal, the patient is imminently going to die, is going to be permanently unconscious, won't survive outside the ICU, or the burden significantly outweigh the benefits, right? And I just want to flag that almost all of these would all fall inside of the provisionally inappropriate category under the model policy. And moreover, almost all of them are heavily value laden, right? Not really in the domain of expertise of clinical judgment. All right, so prevalence, there is a lot of literature on the prevalence of futility disputes. In this month's Critical Care Medicine, it's described as, conflict in the ICU is described as being in epidemic proportions. But I'm not going to review that literature with you because, again, I don't think that you need any convincing here, right? Again, your WEN study showed that 11% of patients in UCLA ICUs received futile treatment and another 9% received probably futile treatment. And I would just note that that's likely to rise because of right now what we have is a lot of clinician-driven overtreatment, right? So futility, again, is usually framed as a problem with surrogate-driven overtreatment. The far bigger problem that maybe isn't discussed as much in the bioethics literature is the problem of clinician-driven overtreatment, right? And so you have you've probably seen this many times before, right? The Dartmouth Atlas data, which shows the amount of variation in treatment, including treatment at the end of life. And so many clinicians are providing all sorts of futile treatment because of their own theory or philosophy of medicine, or they're not good at talking with the surrogates, they have their own prognostic or moral uncertainty, or just due to financial incentives. But most of those things are all changing. So as those change, and clinicians are less likely to provide overtreatment themselves, when the surrogates ask for that same treatment, clinicians are more likely to resist. So let me just turn there and then quickly look at the causes of medical futility disputes. It's basically the gap between what surrogates want and what clinicians are comfortable providing. So this is just one survey. It was from the Archives of Surgery, and they asked about 1,000 members of the public and 1,000 clinicians. If doctors believe there's no hope of recovery, which would you prefer? 21% of the public said if there's no hope of recovery, nevertheless, all efforts should continue indefinitely, 21% of the public, but only 2.5% of clinicians, right? So that's where the futility conflicts come from, is the gap between what surrogates want and what clinicians are comfortable providing. So let me just look at both sides of that equation of the dispute, surrogate demand and reasons for providers resisting those demands or requests. And I'm going to do this quick because I think you're probably already familiar with this, right? So there are cognitive reasons. Surrogates sometimes just don't understand the prognosis. And in fact, this is often iatrogenic, right? Because the reason they don't understand is often due to inadequate communication or due to conflicting or uncoordinated information coming from multiple different specialists. Mistrust comes in several different forms. There's prognostic mistrust, right? Surrogates increasingly do their own research and they feel more empowered to challenge and question the clinicians. There's racial mistrust, financial mistrust. There's a fear of death panels. There are emotional barriers, whether it's things like family dynamics, feelings of guilt, the relationship between the surrogate and the patient, feelings of loyalty between the surrogate and the patient. There are psychological barriers, right? Surrogates are obviously acting under significant amounts of stress and depression. And there's often a sense of optimism that, look, if we can put a man on the moon, then we can save mom, right? The world mortality rate remains 100%. But some feel like King Canute, that they can hold back the waves Or like Winston Churchill, right? Never give in, never give in, never, 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 never. And this sort of optimism is fueled by books like Sanjay Gupta's Cheating Death, right, which is all about these medical miracles, or by research like that of Adrian Owen, right, who uses the fMRI to communicate with long-time vegetative patients. Some surrogates are just in denial, right? They just think that the grass is greener on the other side, or they just want to assert their autonomy. But the really big reason is religion, right? We in the United States have a big belief, this is from the Archives of Surgery again, have a big belief in miracles, right? 57%, right? If doctors said your family member, if the doctors treating your family member said futility had been reached, would you believe that divine intervention by God could save your family member? 57% said yes. And religion underlies the most intractable of the intractable disputes, the ones that just never get resolved. And all of these reasons, cognitive, distrust, and so forth, they're all easy for surrogates to act on because the costs are externalized. And I mean both the financial costs are externalized to a third-party payer, the moral and stress costs are basically borne by the nursing staff because the patient isn't there day in and day out. So I think it's easy for them to act on any or all of these reasons. And I think that surrogate demand is maybe going up, right? This is from a Pew Research study published at the end of 2013, Views on End-of-Life Medical Treatment. And one of the questions they ask is, which of these comes closer to your view? Or in other words, do you agree with the following proposition? Doctors and nurses should do everything possible to save the life of a patient in all circumstances. When they asked that question in 1990, 15% of the public agreed with that. When they asked it in 2013, 31% of the public agreed with that statement, right? It more than doubled. And this is actually consistent with the California Healthcare Foundation. So this is a California-specific study, 27%. So it's basically maps on to California-specific survey data. And this is just an average, right? When you break down the data and drill down a little bit, you look at, for example, just black Protestants, 54% agree we should do everything possible to save the life of the patient in all circumstances, and Hispanic Catholics, 66%, right? So really high. So that's the surrogate demand side, right? So moving over to the other side of the equation, why do clinicians resist? Well, they want to avoid patient suffering, right? They don't want to be complicit in what they consider to be torture, right? And futility, in fact, has been analogized to Nazi atrocities, right? This is the Massachusetts General Hospital, not Auschwitz, a quote from the ethics committee there, or analogized to the atrocities in Bosnia. Clinicians want to avoid moral distress, right? It's the leading, futility disputes are the leading cause of moral distress among the nursing staff. And it impacts not just the nurses themselves, but also others because of the impact on absenteeism, retention, and the quality of care that the staff is able to provide. Clinicians want to preserve the integrity of the medical profession. They're not just vending machines or puppets. Clinicians want to be good stewards, not of healthcare resources, but not just healthcare dollars, but also ICU beds. Right, the ICU, and I think again this is well borne out in the WEN study. Right, there are people in the ED waiting for a bed in ICU, or people from a referring hospital waiting for that bed who have a better prospect, a better potential for benefit, who are going to be denied of that potential. But I think actually one of the biggest reasons, and I'm going to come back to this one, the biggest reasons physicians resist the surrogate demands is because they don't trust the surrogate. Right, they doubt that what the surrogate is asking for is really what the patient would have wanted. And the data suggests that that's right. I mean, surrogates aren't very accurate in making the same decision that the patient would have made for herself. So ideally, we can prevent disputes from arising in the first place, right? Prevention is always better than cure. So what I want to do is start up at the top of the funnel, right? So if you think of all the futility disputes, if we could stop them at the top of the funnel, at the first filter, that's good. at prevention. And the reason to have some optimism about prevention is because we know from lots and lots of surveys that most patients would trade a length of life for quality of life. Right? We know that 70% want to die at home, but only 20% actually do. So we need to do a better job of matching up preferences and treatment. One good tool for this is Pulsed, really good tool, which would work even better if we actually paid clinicians better to complete Pulsed with patients. Also helping are mandated disclosure laws requiring clinicians to discuss patients' end-of-life options with them, mandatory CME on end-of-life and palliative care, more voluntary disclosures being endorsed by the professional medical associations, and better informed consent tools, things like videos and other sophisticated patient decision aids being developed pretty rapidly now with funding from PCORI and AHRQ and other funding sources. And there's also another good sign for optimism is there's actually more social awareness and more discussion in society. Things are on HBO, on Showtime, right? We're talking about death more. It has a little bit more visibility than it used to. But there are certainly some big limits to prevention, right? If you just go back to the Pew study again, 30% really do want to continue all measures and continue and sustain life under all circumstances. And most of the 70% that don't haven't documented their wishes otherwise. So we will have futility disputes, right? So we're going to have to move down the funnel a little bit from prevention. So at least when the disputes are going to arise, hopefully we can at least resolve them collaboratively and reach consensus. And there's 3 ways to do that: negotiation, mediation, transfer, and getting a new surrogate. So first, negotiation, mediation. What people usually mean by this is convincing the surrogate to change from basically saying go to agreeing with the clinicians to saying stop. It doesn't have to mean that, but that's what people usually mean. Well, the good news is that this actually works, right? The data suggests this works 95% of the time, right? One recent LA study from Kaiser, right? They started with 92 futility disputes, and then after the first patient, once it had been identified as a dispute, the first patient conference, 70 of the surrogates agreed then with the recommendation from the clinician. After the second meeting, 79 of the 92 agreed, and after the third, 87 of the 92 agreed. So only 5 of the original 92 futility disputes were intractable. And this is, you see the same exact thing from the older published studies from Prendergast. 57% agreed immediately, 90% after 5 days, and ultimately 96%. Another study by Garros, 95%, Fine and Mayo, 95%. And then in a really big Texas study of almost 3,000 futility disputes, 95%. Only 60 of 3,000 were intractable. Consensus was reached. So this is good, right? And this is why the AMA model policy focuses 4 of its 7 steps on things like a deliberation and a negotiation, because it works, right? You had Tim Quill here last month, so I'm not going to get into how to use these tools of negotiation and communication. That's not my skill set. I just want to flag that this high success rate of 95%, right? So most futility disputes, consensus can be reached. We only have this small subset, this small subdomain of intractability. So we're down now at the really bottom of the funnel. We tried to prevent them. We could reach consensus on a lot. Now we just have this 5% down at the bottom of the funnel. And again, this is where I'll focus the rest of the talk. Even here with these intractable conflicts, we might be able to have a consensus-based solution by transfer, right? So even though you don't want to provide the treatment that the surrogate is asking for, maybe there's another facility that's willing to provide that treatment. basically, so here what you're doing is you can't convince the surrogate to switch from go to stop, but you can switch the clinician or the facility from a stop facility to a go facility. Now this is rare, but it is possible, and sometimes these transfers can be found. If you can't switch the facility, maybe you can switch the surrogate, right? So the problem in a futility dispute is that you can't get, the clinician can't get consent from the surrogate, but maybe you can get a new surrogate who will consent to your proposed recommended plan. Remember now, surrogates are supposed to act using substituted judgment, and if they can't do that, then to make decisions according to the patient's best interest, right? They're supposed to step into the shoes of the patient, right? And this is codified in the probate code. But we know, right, from basically an amazing amount of published studies now, that surrogates aren't real good at this. In fact, they're pretty bad, right? The accuracy rate is about 60% in terms of the surrogate making the same decision that the patient would have made for herself. And not only is that a high error rate, the error rate leans all in one direction, which is surrogates are overwhelmingly way more aggressive than patients would be for themselves if they had capacity and were making their own treatment decisions. Now, surrogates are performing a new job under tough circumstances. So I'm not saying we should rush in and replace them and bump them out. We should support them, right? This is in the Code of Medical Ethics too. We should give them tools. This is just one from the American Bar Association. We should give them tools so they understand what their role is. But if after this support, if they persist in deviating from the applicable decision-making standards, then they can and should be fired, right? And this is also codified in the probate code, right? You can make a petition if the agent or surrogate is not acting consistent with patient desires. And you don't even need to do the petition, right? Because the probate code says you don't even need a judge. You don't need to go to a judge to do this. Rogue surrogates can be ignored, right? You don't need to follow the instructions of a rogue surrogate. So why would you ignore? Why would you try to replace a surrogate? Well, some reasons are pretty easy, right? One is obviously if they're suffering from a material conflict of interest. In one case that comes up, and it's sort of sad, but it comes up quite a bit, are parents who have beaten, performed child abuse, and now the child is in a person's vegetative state. The recommendation is to stop life-sustaining treatment. They won't consent, but the reason they won't consent is because that's going to escalate the criminal charges from child abuse to murder, right? So clearly not the right decision makers. So they're regularly replaced as the people making decisions for the children. Another easy example is where the surrogate contradicts the clear instructions in the patient's advance directive. So we had a case recently in Minnesota where Al Barnes had an advance directive clearly declining treatment under his then clinical circumstances. But his wife, Lena, insisted on continuing treatment. Well, hospital went to court. Lena was replaced with a professional guardian. And there have been dozens of these cases over just the past couple years, right? In New York, Dorothy Levatas had an advance directive saying stop, but her daughter and healthcare agent said go, continue the life-sustaining treatment, right? She too was replaced. And even here in California, surrogates are replaced when they demand more aggressive treatment than it is that we know the patient would have wanted for themselves. Even in the tougher case, when we don't have an advance directive from the patient and we're saying that the surrogate is deviating not from a subjective standard but an objective standard of best interests, surrogates are replaced. When the burden-benefit trade-off is such, when burdens rise relative to benefits, surrogates are going to need more evidence, better evidence that that's something that the patient would have accepted, that kind of trade-off. In New York, Gary Harvey's wife was replaced, and the court explained, look, you failed to follow medical advice, you failed to use good judgment. At the Mass General, Barbara Howell's daughter was replaced as her surrogate. The court said, look, your own personal issues are impacting your decisions. I urge you to refocus your assessment. And I just want to make one final point about the surrogate replacement, is I think it's not just an option, right, to resolve it. I think it's a duty. And let me just give you an example. Well, let me do this first. So Stephen Stills, right, you may recall, had this song, if you can't be with the one you love, love the one you're with. Well, this may or may not be good advice in your romantic life, but my point is it's bad advice when it comes to medical surrogates. Let me give you an example from across town at USC, okay? Placentia McDonald had an advance directive, and basically there's three things in the advance directive that I want you to know. She appointed her son Bobby as the agent, her daughter Cynthia as the alternate, and basically the advance directive said, don't prolong my life if I'm in an incurable condition. Well, she goes in for surgery on a thoracoabdominal aneurysm, but unfortunately has some post-operative infections. That's middle of August. By the end of August, she has sepsis, she's non-cognitive, but Bobby, healthcare agent, authorizes continued life-sustaining medical treatment and 3 additional surgeries. Cynthia, meanwhile, the alternate agent, Bobby's sister, thinks this is all wrong and this is not what mom would have wanted, okay? Well, they follow Bobby. Ultimately, the patient dies. Later, Cynthia sues USC for damages, right, after the fact. USC argues, well, we have immunity, right? You can't sue us. We were just following the duly appointed healthcare agent, Bobby, and the probate code gives us immunity for doing that. Well, the California Court of Appeal says, not so fast, USC, because you only have immunity when you comply with the healthcare agent in good faith. And compliance with an agent's decision at odds with the patient's own advance directive is not compliance in good faith. In other words, the agent wasn't authorized to depart from the advance directive, and you should have known that. So they lost immunity, had to go back to the LA Superior Court. Now, surrogate replacement works, but there are some real limits, and here are 3. One is providers can't show deviation a lot, can't show that the surrogate is deviating because we don't know what it is the patient would have wanted, so it's hard to establish that the surrogate is not doing what the patient would have wanted. Most people don't do adequate advanced care planning. Second, surrogates get the benefit of the doubt anyway, right? The presumption is that you're going to follow the surrogate, and if you're going to rebut that presumption, you're going to have to show a deviation that's pretty wide of the mark, and so that may be difficult to do. But probably the biggest limit to surrogate replacement is that the surrogates are faithful, right? They're loyal and faithful. They're good surrogates. You can't replace them. They're doing their job. So let me give you an example from Ontario, where in Ontario they have a special tribunal called the Consent and Capacity Board, which regularly replaces surrogates in futility disputes, but not in the recent Hassan Rassouli case. Why? Because the reason that his family, and he's been in the ICU for 3 years, the reason the family was asking for that treatment was because of the patient's own Muslim faith, right? They were exercising substitute judgment. They were doing their job as surrogates, and there was really no basis to replace them. Okay, so if you can't get consent from the surrogate, and you can't get a new surrogate from whom to get consent, then you're going to have to, then you have an intractable conflict. And here, there are 3 dispute resolution pathways. Right? You cannot get any authorized consent. You can take covert action, you can cave in to the surrogate, or you can unilaterally stop without consent. So covert action, I mentioned this, basically without legal support to withdraw or withhold openly and transparently, some do it covertly. And there's a couple studies out there on this, but the ASH study showed that 14% of responding physicians withdrew life-sustaining treatment, not only without consent, but also without even the knowledge of the patient or family. And I just want to flag that this approach entails some legal risk. And so the good news is providers have won almost every single damages case for unilaterally withdrawing life-sustaining treatment that's been brought. But if you look at the subset of successful cases, almost all of them have one common legal theory, and that's intentional infliction of emotional distress. In other words, what those defendants were sued for was not so much for unilaterally withholding and withdrawing treatment. They were they lost those cases because they did so in a secretive, insensitive, or outrageous manner. So it was the way in which they withdrew it, not the fact that they did it. Also, unilateral or covertly withdrawing treatment would also violate an express requirement of the probate code, which requires that if you're going to decline to comply, you shall properly inform the patient and/or surrogate. All right. So another dispute resolution pathway, the second way to handle an intractable dispute, is probably the most common, which is you just cave in, right? You don't think what the surrogate is asking you to do is something you should be doing, but you go ahead and do it anyway. And when asked, and there's lots of surveys that ask this question, when asked, doctor, intensivist, why did you follow the substitute decision maker instead of doing what you thought was right, most cite a lack of legal support. There's other reasons, but I'm going to focus on the lack of legal support as the reason, right? And I think there's a threat. Sometimes it's implicit, sometimes it's explicit, but there's a threat of suit there. And so overriding the surrogate appears risky, like crossing this bridge, while caving in seems safer, like crossing this bridge. Plus, it's easier, right? The patient's going to die soon. You're going to round off next week, and the nurses are going to bear the brunt of this in any case, right? So it's just not worth your time. And you're still worried about potential legal sanctions. And there are some, right? There are some. There's potential civil liability, whether tort-based or statutory-based. There's potential investigation from the medical board, and even criminal penalties. So let me just drill down for a second on what exactly is the legal risk. There have been hardly any cases, really, people getting sued for unilaterally withdrawing medical treatment. I think one reason is that surrogates actually feel relieved, right? That you took the decision away from them, right? You relieve them of the burden of them having to make the authorization, and you just went ahead and did it. Another is that the really vitalist surrogates, like in the Mcmath case, are going to sue ex ante, right? If they really feel that we need to keep the patient alive, they're going to sue for an injunction ahead of time. They're not going to wait until you unilaterally withdraw and then sue for damages. So often the absence of the ex ante case generally means that there's not going to be an ex post case. But let's say you have a surrogate who truly is angry that you went ahead and stopped without consent. Well, it's nearly impossible to get a medical malpractice attorney to take a case worth under $250,000 or $300,000. And as you know, the patients that we're talking about are usually elderly and/or critically, chronically ill, right? There's no lost wages here, right? There's nothing that comprises what you'd call economic damages, which is what the value of a medical malpractice case is. So the whole potential value of a malpractice case is going to come from non-economic damages like pain and suffering. But under the California malpractice reform, that's capped at $250,000. Although, depending on how you vote in November, it might go up to $1.1 million next year. But bottom line, futility cases, not a good investment, right? Which is basically what malpractice cases are. They're investments because all the experts have to be hired by the malpractice attorney. It's his money. They're not good investments, so those cases aren't real attractive. Even when they are brought, they're hardly ever successful. It's hard to establish causation. It's hard to establish a duty of care. Plus, even in a regular malpractice case, if you have good medical records, good documentation of why you did what you did, again, that's a deterrent. The plaintiff's attorneys don't want to take those cases. And if you follow your own futility policy, basically by getting the second opinion, by getting the ethics consult, and by going to the ethics committee, it's just more, you might be described as just more documentation showing that the process is even more deliberative. So the rule that good documentation deters malpractice could be extended and say following a futility policy is just more documentation deters. But perception of risk is more important than actual risk. Perception is what drives physician behavior, not actual risk. And moreover, the risk is greater than zero. It's close to zero, but it's not zero. There have been settlements and there have been judgments. Worse, when I say there haven't been a lot of successful cases, I sort of suspect that that's a self-fulfilling prophecy, because it's not that the fact that clinicians are winning all the futility cases that are being brought, it's that they just aren't being brought. Why? Because clinicians are caving in. And so there isn't a denominator. Plus, notwithstanding the economic equation I just gave you, there are entities that will fund these suits, not because they make any economic sense, but because they want to make some policy, achieve some sort of policy objectives. So there are sort of pro-life organizations that will fund the litigation just to basically send a scare message out to intensivists. Even if we knew, and I don't think we do, even if we knew that that patients would always lose a futility case for damages if they brought it, I don't even think that would be enough, because clinicians aren't just liability averse, they're litigation averse, right? In other words, the process itself of whether it's medical board investigation or litigation is itself punishment, because even if you win, even prevailing parties pay transaction costs, and that, whether that's in terms of your time, your emotional energy, or your money. Yeah. So at one level, this is just one species of defensive medicine, right? This is not so different than all the scans, maybe a third of all scans performed in the United States, which are performed for legal reasons, not for medical reasons. So one way you could describe it really simply is that what clinicians are complaining about is bad law, meaning the law makes them do bad things. They don't feel sufficiently safe to do what they think is the appropriate thing. The normal reaction to a bad law claim is a legal safe harbor immunity. In other words, this is what we have, for example, with elder abuse reporting or child abuse reporting, right? You can't get in trouble for breach of confidentiality because we want those reports to be made, right? So we give people immunity to incentivize them to do what we think is right. And this is well stated recently by the European Court of Human Rights. In the medical environment, practically everything is regulated. Regulation is the default. Only what is regulation is considered safe. So if you don't take covert action, though, and you don't cave in, then basically you're going to go ahead and openly and transparently stop life-sustaining medical treatment without consent. Right? We're down at the very bottom of the funnel. And what I like to do is describe or summarize the legal situation in the United States by using the metaphor of a traffic light: green, red, yellow. And what clinicians want is a green light, right? They want, and a green light says, go ahead, do what you think is right, and you're safe, right? You can pass through. The main example of a green light is Texas, where the law says to the clinician, you may stop life-sustaining medical treatment for any reason, with civil, criminal, and disciplinary immunity, so long as your own hospital ethics committee agrees with you. There's a couple other steps, but that's basically what the law says. And it's been used quite a lot over the past 14 years. In fact, it's seen as a model in other states that they want to copy. They're like, we want a law like Texas. Right? And there's been resolutions passed in the California Medical Association, Washington Medical Association, Wisconsin. It's been more formally tried in all three branches of state government. The Idaho Senate passed a bill completely copied on Texas, so it failed in the Idaho House. Maryland tried, so that's the legislative branch. Maryland tried to copy Texas through administrative agency regulations, the executive branch. And New Jersey tried to copy Texas through the courts, the judicial branch. But those all failed, and Texas basically remains alone. Now, there is a second green light in the United States, and that's the conscience clauses, right? These are clauses often focused a lot on the reproductive rights context, but they usually encompass protection more broadly than that. And that's where they basically tell the clinician, you can refuse services for moral or conscience personal reasons. Now, most conscience clauses in the United States require treat-till transfer, which means you can refuse, you can stop, but not until you find somebody to take over for you, to replace you. But that condition, that limit on conscience-based objection has been increasingly dropped, right? So Mississippi no longer has a treat-till transfer requirement, and just in the last 18 months, That's new conscience clauses, much more broad conscience-based objection protection, enacted in Nebraska, Michigan, Kentucky, and considered in some other states like Oklahoma. A third green light, these are basically, when I say green light, right, you're allowed to go ahead and stop treatment that you think is inappropriate and you're safe, is in Vermont, the POLST regulations allow the clinician to write a POLST, a DNR, not without patient consent, without surrogate consent, but on the basis of medical futility. And in Maryland, actually, the Maryland most regs now do the same thing. You can write a unilateral DNR on the basis of futility. And a fourth green light is medical repatriation, which is basically, at least for undocumented residents, another sort of transfer provision to deal with medical futility disputes. So green lights tell the clinician you can stop. A red light is the opposite, right? It says you can't stop without consent. You need consent. Ontario has, like I said, the Consent and Capacity Board. You could try to replace the surrogate. But late last year, the Supreme Court of Canada said, if you can't replace the surrogate and get consent from a new surrogate by going to the Consent and Capacity Board, then you have to comply with the current surrogate. In other words, you always, always, always need consent. I don't care where you get the consent from, but you always need consent. And that's the same rule that we have in New York, which says if the surrogate directs life-sustaining treatment that the provider doesn't want to provide, you shall nonetheless comply. Idaho, healthcare may not be denied if it's directed by the surrogate. Same thing in Oklahoma. Alaska tried it. In Minnesota, we're a partial red light state. So you have to comply. You have to comply with the healthcare agent. In other words, if the surrogate's appointed in the advance directive as a healthcare agent, you got to comply with them, but you don't have to comply with default surrogates or conservators or guardians. Those are procedural red lights. I'm sorry, those are substantive red lights. There's also procedural red lights. And what I mean by that is courts regularly grant injunctions in futility cases, right? And so the Mcmath case never adjudicated on the merits, but they got weeks and weeks of extra time in the hospital. And Mcmath's attorney says, look, I come in and I use the law to say stop, right? Because in most futility cases, we have life and death stakes, unclear facts, unclear law. And given those equities, the court is almost always, and they do, going to grant the temporary restraining order. Not declaring that the family has the right to any treatment, not declaring any rights and responsibilities, but just saying, stop for now, it's a stopgap measure, we just want to preserve the status quo until we can gather the evidence and figure out what's going on here. But that takes time. The judicial process is slow and cumbersome. And basically, time is all really the family wants anyway, so just by using the judicial system, they get what they want, even though they technically don't win in court. The process itself gives them a win in the sense that they get what they wanted. Okay, so let me finish on this. We have this handful of red light states, and we have a handful of green lights. Everything else is yellow, and I'm going to call California yellow. It's not red, certainly. And maybe more controversially, I'm going to say it's not green either. It's yellow, meaning it's not clear, right? It's not clear if it's safe to go through the intersection. Now, people say, hey, California's green. Look at Probate Code 4735. It says, the provider may decline to comply with a surrogate request that's contrary to generally accepted healthcare standards. And then 4740 says, if you use 4735, you have civil criminal and disciplinary immunity. So why isn't that a green light? And in fact, the California Medical Association in their guidance, well, one of the questions is, does California law support physicians who decline to provide medically ineffective or non-beneficial treatment? Yes, it does. So some people think it's a green light. But let me break this down into two pieces, when and how you can use the safe harbor in 4735. Let me start with how, because that's easier. How? Well, if you're going to decline to comply with a surrogate request, it says you have to provide continuing care until a transfer can be accomplished, or, and this is the key part, or until it appears that a transfer cannot be accomplished. And that's significant because if you want to refuse, you have to try to transfer. If you can't find a transfer, you only have to comply until a transfer appears impossible. Most other states have a treat till transfer requirement, meaning If you want to refuse, this is the other stage. If you want to refuse, you try to transfer. But if you can't transfer, then you have to comply, right? So that's a big deal. That is a nice aspect of the safe harbor. The tricky part is the when. When can you use 4735? Well, what the surrogate is asking for is contrary to generally accepted healthcare standards. The problem is, what are those? There is enormous variability across ICUs, across individual clinicians, and even across the same clinician from context to context, right? This isn't good. Even in quantitative, you ask people, well, is it a quantitative measure of futility? Some people would say, oh, it's only futile if it has a 0% of effectiveness. Other people would go up as high as 13%. 4735 presumes that there's this domain of generally accepted healthcare standards that we can define, and then you'd know that what the surrogate is asking for is over here outside of the generally accepted healthcare standards. And that's just not the reality. We don't really know where the boundaries are, if there are any boundaries of what the generally accepted healthcare standards are when it comes to intensive medicine. We have a couple, right? Brain death, well, even that's becoming a little bit unsettled. We have brain death, anencephaly, 22-week and under gestation, and pure physiological futility, none of which are real helpful with most of your futility disputes. For a safe harbor to work, it has to be clear, precise, concrete, and certain. And 4735 is not, because it's linked and anchored to a vague substantive standard. In Texas, it's procedurally defined. 48 hours notice of the ethics committee, 10-day waiting period, right? You can measure that on a clock. You know when you satisfy when you're inside the safe harbor. California, you don't know when you're inside the safe harbor. So clinicians still worried about legal sanctions. The original California Medical Association resolution was, look, physicians feel threatened, change the law. Well, that never happened. You have the same law. So I guess my contention is they still feel threatened. Worse, I think things actually are worse, because by continuing to provide futile treatment, clinicians are reinforcing the very standard of care that they don't want to comply with, right? More than 1 in 10 patients at UCLA gets futile treatment. You're reinforcing, you're creating the wrong standard of care, right? The law gave enormous deference to physicians to define the standard of care, to define when it is that you can decline to comply. But I would say that basically they dropped the ball. Now, I think that may be changing, so I'll try to on a positive note. That may be changing. I think that some professional medical associations, like the renal physicians, are issuing stronger clinical practice guidelines, for example, recommendations about if dialysis is indicated for patients in a vegetative state. And then finally, even if there is variability with ICU standards of care, it may be sufficient that you're part of a respectable minority, or so-called school of thought, right? So in medical malpractice litigation, we recognize more than one standard of care. So I think when we're looking at interpreting 4735, there may be more than one set of generally accepted healthcare standards. So it may be sufficient for 4735 that the surrogate request is for treatment contrary to one set of generally accepted healthcare standards, even though it may be consistent with another set of generally accepted healthcare standards. That's why the transfer provision is there, to give them a chance to go find somebody who follows the other set of generally accepted healthcare standards. So I think the only challenge then is to actually make sure that this is a bona fide school of thought by making sure that it's supported by a significant number of clinicians and a significant number of respected clinicians. But until that happens, if California is a yellow light state, because of the legal risk averseness in the medical profession, a yellow light state is generally perceived and operates basically the same way that a red light operates. Oh, and I'm on the program committee. So in October, if you're really into bioethics, please come down to San Diego and go to the American Society of Bioethics and Humanities conference. So, time for questions? All right.
Well, lines because there is only one standard of medical care for the United States, nominally. And they don't have to be licensed in a particular state to testify in malpractice litigation. But you're saying that this is not true. And would it take a decision by the U.S. Supreme Court to change this issue for the whole country?
He said, I wish I could give you a mic. Okay. I want to make sure I get...
For purposes of medical malpractice litigation, expert witnesses can testify in any state because it's commonly accepted that there's only one standard of care for medical care. But your talk says that it...
No, so he's saying that...
In this instance...
Right. So the question was that there's a presumption that there's only one standard of care that's uniform in the United States, and the question is that, well, I suggested that that's not true. Two quick responses. One is that varies from state to state. So many states in the United States, you have to be from specific states. In Tennessee, you cannot have a medical malpractice case unless the expert witness is from Tennessee or from a state that's contiguous and touching the state of Tennessee, which whatever that is. It's a lot of states, Mississippi, North Carolina. But anyway, so it varies, okay? Varies a lot from state to state. But what I wanted to get on with the school of thought is I'm saying in the United States, right, there could be more than one standard of care, right? There's some physicians who think, oh no, just because a patient is in a PVS state doesn't mean that we don't do dialysis. And then there'd be a whole bunch of other nephrologists who would say, no, we don't do dialysis on people in PVS, right? So I'd say there are two standards of care, even if you say we have a nation, which is not true, but let's just assume for a second, we do have a nationwide standard of care. What I would say is we have two nationwide standards of care. There's two ways of doing this in the United States. So whatever your geographic measure of the standard of care is, I'm saying there's two standards. Yeah.
Thaddeus, thanks for a great talk. I just wanted to ask you, since you didn't talk all that much about Jahi Mcmath, we often talk about medical integrity. Can you comment a little bit about the legal integrity of the injunction holding up to Jahi Mcmath in the intensive care unit for so long, and whether or not you think that sets a precedent for California, and how might it have been handled?
So, and I think the clever thing is, first, that there's different phases of the litigation, right? So at first, they disputed that she in fact was brain dead, right? So for the court to order an injunction to say, no, you have to keep the cardiopulmonary support, they weren't literally saying you have to keep supporting her as a corpse, because we don't, that's exactly what's in dispute. So they factually disputed that she in fact was dead. And so, at least for the first part of it, I don't think that's as troublesome, right? And in fact, I think in all the old cases where parents, it's usually parents and small children, disputed brain death, I think that they were clever enough not to challenge the fact, not to challenge what the appropriate thing to do is once somebody's declared dead, but they in fact challenged the diagnosis itself.
Is that all right? Because, it only takes two physicians, and that is under California.
Well, that's one thing that did come out of the case, which I think is interesting. The statute says independent confirmation, right? And the way the judge interpreted that was independent of the facility, not independent of the clinician. Which I think that's interesting because that could have implications for futility cases as well. But that's one interesting thing. That's why they had to go to Stanford, because the hospital thought I think they had four, right? So they had four, which is way more than they needed. They had four confirming diagnoses, but the judge said no. The statute says independent, so we need to get somebody from outside of Oakland Children's. But I don't know. I don't think so. I'm not that troubled that this is going to set a precedent, except for what I said, which is this shows people that even with what's really a legally baseless suit, right? I mean, it's clear that what brain death is, the definition. Once the clinical confirmation came in, that was settled. But it shows that they were able to extract things that they really weren't entitled to, right? Weeks of extra time of supporting a corpse in the hospital, a transfer. So it shows that if you get the right attorney, you can get stuff that you never would have been entitled to. So I think it gives people a sense of optimism that they can use, even with a baseless suit really, they can use the judicial process just because of the slowness and the way it works to get weeks of extra time. I think the same thing happens in futility cases. Yeah.
I may have missed this, but you pointed out that religion was like a big problem with this whole process. What is the main solution for that biggest problem?
I think that's a really good question. I think if you just look at two of our other common law, we often look to either Britain, Canada, or Australia, or other, common law jurisdictions. In England, right, they don't care, right? So basically you could have somebody who you absolutely, they're Muslim and they really believed that we needed to keep going. The court said no. The clinicians think it's inappropriate to continue. Clinicians, you can stop, right? So basically, medical judgment was allowed to override religious belief in the UK. Supreme Court Canada case, like I mentioned, basically the rule there now is, that, again, another Muslim patient, religion trumps medical judgment, right? So so they basically have you have UK on one side, Canada on the other side. I don't know where we're going to strike that balance, right? And I don't know if there's a middle ground between saying medicine trumps religion and religion trumps medicine, but that you have two other countries which took the extremes. I don't know I honestly don't know what the right answer is. Yeah.
Last time when Tim Bell came to talk to us, he talked about methods of negotiations in intractable cases. And one of the solutions that he came up with in a case where they couldn't negotiate, where it was clearly futile, and what he did as the counsel for the ICU team was that the physician should just do one round of CPR and call it quits and not tell the patient that that's what we're going to do. In my mind, that's like a half-ass coping, basically. How do you think that would play out if that became public knowledge in the courts that that's what the doctors did? The patient died, obviously.
So right, okay. I didn't break this down, right? But I think when you're talking about futility disputes, when you talk about CPR, that is handled differently, and so I think that there's some more options there if you focus just on CPR, right? And so. I'm not quite sure where I settled down. I mean, there are people who say you could either write a short code or a slow code, there's different ways to handle that. I think that what you're saying is a short code, which is you're actually going to show up, but you're just not going to continue as long as you otherwise would. I think that is probably generally safer because you're not making an ex ante judgment, writing a DNR or unilateral DNR order. You're saying I was there at the time and I used my clinical professional judgment that it was time to stop. I think it's going to be enormously difficult for that to be successfully challenged. I might just note that in the one case that I could think of where there was a suit and actually was successful, it was in a state that has what we call lost chance causation. Okay, so what they're saying is, you didn't perform CPR even though we never consented to a DNR order. Well, normally, in order to win that, you have to establish but-for causation, right? So in other words, you breached your duty, and what you have to establish is, had you not breached your duty, the patient would still be alive, right? But what probabilistically, the patients we're talking about, 99.9% chance it wasn't going to work anyway. That's why you didn't do it, okay? That jurisdiction had lost chance causation, which means they were able to sue for the deprivation of the chance, no matter how small it was. Maybe it's 1%. Well, you deprived us of a 1% chance that it might have worked. California doesn't have lost chance causation. You have to establish that more likely than not, the thing that you didn't do would have worked, and so, which I don't think you can establish. So anyway, I think short code's legally safe. Not super. I mean, I'm troubled because obviously it's a little deceptive, but.
You don't think it falls under your covert category?
I think. I mean, if you haven't read it, John Lantos has written a couple really good defenses of short codes in the American Journal of Bioethics and somewhere else, and it's pretty persuasive. So that's a good question. I'm not sure if I would put it right into that covert category. Yeah. Medical procedures need to
Consent.
yeah.
Why does CPR not need consent?
I mean, yeah, it's a good question. I mean, people have written about this. It's this one weird procedure that you have to opt out of rather than opt into. And you're asking why. It's a historical anachronism. It goes back to when CPR started in the 60s. People have made, again, some really good defenses that we should change that. And I agree with that. I think we should. I think that the defaults, right? So the default, if you're going to establish a default rule for anything, including here, the default should be the thing that more likely than not is the good rule, right? And let me read. This is the whole theory of behavioral economics, which is you make the defaults the best thing, and you don't literally take anybody's freedom away because they can always opt out of the default. So I absolutely agree that we should make the default no CPR, and if you want it, you can consent back into it. So I think it should be flipped. I can't give you a real great historical explanation for why we're here today with. Yeah.
Setting aside whether short codes are legal, are they ethical?
The question was, putting aside whether short codes are legal, are they ethical? I think they are. I mean, because again, there's always going to be some amount of judgment and discretion as to how long you're going to code. Always, right? You'll always have to make a judgment at some point. So I think they are. Yeah.
But that data is available because nurses chart the exact duration of codes, and we have that information. The average code is probably 20 minutes. If you go 2 hours, it's an outlier. If you go 1 minute, you're doing something that's specious. So clearly, if you're several standard deviations around the average time of a code, 20 minutes plus or minus 10 minutes, you're within the usual length of
Unless the patient, so you're saying you're right. If every other patient is 20 minutes and now you're doing 2 minutes, it looks like you're an outlier. Unless there's a reason that you could point to some materially different facts about this patient that would say, well, they're distinguishable. If they're not like that population, that's why we're treating them differently.
Well, unless the code team isn't informed about the full clinical picture of the patient, and they start and then realize this is either no code or the patient's terminal.
Yeah. No, yeah.
But doesn't ethics predicate itself on honesty? And performing the code, in the opinion of learned professionals, is inappropriate. And I'm performing it with the idea of making the show. I think it was that terrific book, House of God, talked about the needle in the bed from the 1970s. Either you stand on the firing line or you don't. But I think there's something inherently dishonest. And when physicians and healthcare providers cross the line of honesty with our patients, the law of unintended consequences, and we sort of pointed out things like the Tuskegee Institute, where in the black community there's an inherent documented distrust, reasonably so, and many other things. Doesn't that cause a problem? And the solution really is not to perform codes that are inappropriate, but to go through, as most of you talked about, some sort of conflict resolution.
Yeah.
It's very disturbing to me. That honesty question.
Yeah, I agree. I mean, obviously, we should overwhelmingly be honest, but there are already lots of other exceptions, right? So with regular patient-clinician contemporaneous informed consent, we have a therapeutic privilege exception, right? So if we think that by disclosing certain information to the patient that it could have a deleterious consequence, just by giving them the information, you're allowed to not make a disclosure you'd otherwise have an obligation to disclose. So I think this would be analogous to that, which is there's a special narrowly carved exception to what would otherwise be a duty of full honesty and disclosure. Oh. Hi, Santa Monica. Are there questions? I don't know if they have audio. Okay. Yeah.
Is a slow code ever illegal?
A slow. So just to be clear, so the question is a slow code ever ethical or legal? So just to be that's clear, right? So the way I understand it is as a short code, which was a question over here, which is where you show up in a timely manner and you actually perform. You're not pretending. You're actually doing the code in the manner that you normally would. You're just not doing it for a duration of time that you normally would, right? So that's one. Then there's sort of a Hollywood code where you're not even performing the resuscitation in the manner in which you normally would. And then third, slow code, which is you don't even show up, right? You don't even respond to the patient's room.
You respond, but your impressions are not what they should be. The fervor of doing everything is just half-paced. I've actually experienced that.
Yeah. Yeah, I mean, it's similar. So it would be the same argument over here that that's deceptive, not honest. And so there's obviously a great argument. It is. Okay. Right.
The act of knowing, like you go in the room knowing you're going to do this, it's premeditated. I think that's the question. If it's premeditated and you know you're going in and not going to do what you should do or the family wants you to do, it's premeditated. Is that ethical? And I think.
Right. That's why I defended the short code because then at least you say, well, look, I planned. Like when I showed up, I was prepared to do the full 20 minutes. But then, based on how things were going, you say, well, we responded to evolving clinical circumstances. So I what she said, which is when it's premeditated, I think that makes it far less defensible than when you're making it, on the call.
Like the fourth code on the same patient. And the fourth doctor says, I'm going to slow this down.
Yeah.
I just wonder if the honesty question has to do with the honesty with the family versus the honesty to the patient or to the situation. And I think that can be a difficult thing also. Like the doctor might feel it's going against the truth of the situation to do a code on this patient, whereas the pressure from the family is to the code. So what truth are you going to adhere to?
Well, I would only say that if you go back to some of the things I was getting at, when you want to look at the ethical justifiability of this, things like if the patient herself had told you, you're going to code me, right? As opposed to where you really suspect that this daughter just can't you're pretty sure that the reason you're coding this person is only because the surrogate is sort of making you do something that you're pretty sure that the patient didn't want. Then I think that also changes the justifiability of the code because you don't really think this is in the patient's best interest or the patient's, or even contrary to the patient's wishes. So it's never, you have to factor everything you have. I'm sorry, Catherine.
I think part of the problem is the language. So a short code is problematic versus calling a code. Because calling a code gets at what you're talking about, which is clinical judgment of saying this is no longer appropriate. And I think you can legitimately go to a family and say, we completed the code at this point because I called it as a physician. I determined that it was no longer clinically viable. And I think that way, but I think a short code indicates kind of a premeditation and intent versus truly using your clinical judgment in the moment. So I think if language is so important around all of this, that we have to be really clear about what we're doing.
What would you advise a clinician who's usually part of a team taking care of a patient if you feel that the patient was not given, was terminated, or life support withdrawn inappropriately, and you have to decide whether you're going to enter a hornet's nest of calling the VA, who will probably not be interested in taking the case anyway. But what do you advise physicians, or do they not even ask you this question?
So when you say withdrawn inappropriately,
You've been with a patient that you participated in the care, and you come out and you and you think it's bordering on a homicide. That the surrogate told another clinician to withdraw care, and you think it was totally inappropriate.
All right, so you're, okay, I just want to make sure I got your case. So the surrogate, you have consent, you have direction from the surrogate to withdraw care,
Yes.
But you think that the surrogate was acting outside the scope of her authority when she directed your colleague.
Or totally inappropriately from your perspective, but another clinician acceded to the surrogate's wishes and terminated care, life support at a time that the patient was dependent on. And you believe the patient was totally viable and would have recovered. What do you advise?
Right, well, this is sort of what I sort of defended the fact that I think that this happens, and I think that normally we don't challenge surrogates that much. And I think, so I guess being consistent with my theme, I think we should, of course, now it's after the fact, so obviously the stakes are, it would be easier if it was ex ante, because then it would be worth doing. Now your question is, well, why bother? The only thing I say is only because I'm aware of 5 cases that are currently litigation where this happened for selfish reasons. In other words, these are surrogates who killed their parents for the money, okay? And so that happens. And so when you say, should we refer to the DA, just having read these cases recently, I think if it's as egregious as you're saying, that's the way you posited the problem, I think it's...
But it's not just the surrogate, it's the clinician that acceded, you think, inappropriately. And it poses all sorts of internal political problems in the hospital and with the...
Well, then the first, okay, before you call the DA, call your ethics consult, because that's protected by privilege, right, for peer review. So don't rush, get some external advice first. Obviously don't immediately report anybody. But I think, I do think there should be some additional processes involved to get some opinions on how to proceed with that.
So I think we should wrap it up. I just want to remind people that we also have a policy at UCLA, not just the futility policy, but actually within the no CPR policy, the unilateral no CPR, that still has due process, but allows us to not provide CPR in a situation where clinicians believe that it would not be positive. So just a reminder of that, it requires an ethics consult, it requires a second opinion at a very high level. So certainly we have ways of dealing with this within our institution. So thank you for being here today. Thank you, Thaddeus, for... Thank you, Santa Monica.
Yeah,
I